thank you for joining us today. My name is Yongki Hong and I'm a Senior Associate at Scar Legal PC. Today's webinar will focus on how to move from a non-immigrant visa to a green card in the United States. We are very fortunate to have our firm's managing partner Ian Scott as the speaker for today's presentation. I will begin with the overview of family-based green card categories and EB1A category as well. And then Ian will discuss more detailed practical guidance on employment-based green card categories. Before we dive in, let me briefly introduce our firm and go over a few housekeeping items. We are a full-service immigration law firm. We offer representation across a wide range of practice areas, including E2, O1, TN, L1, H1B, and all types of employment and family-based green card cases. That said, we are particularly well known for our work in the complicated green card cases, and we have built a strong reputation throughout comprehensive approaches and strategies. So we have processed thousands of these cases and have been able to secure approvals for the vast majority of them. At the end of this webinar, we'll send you several useful tools. A copy of a PowerPoint presentation we'll go through today, a link where you could download the guidelines with more details on visa options, a link to sign up for additional webinars, a link to webinar recording on YouTube. We definitely encourage you to subscribe and hit the notification button as we regularly post immigration related videos. And lastly, a link where you can sign up a private consultation with our team. Finally, for any questions, please type them into the chat box or Q&A box. We'll discuss all the questions at the end of presentation. And with that, let's get started. So, how does the green card system work? So first thing we need to talk about is the system. US green card system is quite different from other countries. For example, in Canada, they use a point-based system, which gives points all different things like education, language ability, work experience, or even age and other factors. Another example is like United Kingdom's immigration system. In UK, it is not every visa, but certain times like work visas will let you apply for the permanent residency after about 5 years of residence. United States immigration system unfortunately does not work that way at all. Instead, there are several green card categories and you have to simply pick and apply for one based on your eligibilities. So for example, even if you live in the United States for the 10 years with your TN visa or E2 visa, it does not automatically lead to a green card. The US green card system is primarily broken into two ways. One is family-based and the other one is employment-based. Under the family-based, the immediate relatives category is for US citizens' spouse or unmarried children under the age of 21 or parents if the sponsoring citizen is over 21. And the preference categories for the family-based green card case have multiple subcategories. For more detailed information, you may look at the Department of State's visa bulletin, but a couple of good examples for these subcategories are spouse of U.S. permanent resident, brothers and sisters of U.S. citizens are good examples. Employment-based categories are also broken into total 5 subcategories from EB1 to EB5. EB1 is generally known as extraordinary ability cases. EB2 is for also have two subcategories. One is national interest waiver, and the other one is POM case. POM case is where application process is going through the Department of Labor first before you submit the application to USCIS. EB3 is also POM cases going through the Department of Labor based on company sponsorship. EB4 is a religion-based, and finally EB5 is investor-based. For these employment-based categories, EM will address more detailed information later about presentation. So next slide, what is the family-based green card? The immediate relatives are most popular way to process your foreign national spouse's green card case. The preference-based categories have a total 5 different subcategories as well, from F1 to F4, but two well-known examples I just mentioned in previous slide is that the spouse of a U.S. permanent resident and brothers and sisters of U.S. citizens. A, a, a big issue about these preference-based categories is that the case processing time is governed by the Department of State's visa bulletin, which causes a lot of backlogs. This means while green cards for the immediate relatives are always available, the green cards for the preference-based categories may not. Depending on which countries you are from and or which category you are applying for, there may be significant delays before green card is finally processed or approved. For example, F4 category, which is for the brothers and sisters of U.S. citizens. These categories, unfortunately, you need to wait almost 17 years nowadays. Not 17 months, but 17 years. These limited numbers of green card, rule by visa bulletin applies to employment-based green card categories as well. Each employment-based green card category also has annual cap of how many green cards can be issued. Once a particular category reaches the annual cap, the application may experience some delays, sometimes very significant delays. That's why it is important to check the monthly visa bulletin announced by Department of State always when you are preparing a green card case application. Next, let's talk about process for the family green card cases. The review process, application process is basically, it has two parts. First part is the I-130 petition you submitted to the USCIS. Basically, this petition is proving that whether petitioner and beneficiary really has a bona fide relationship. The relationship could be a marriage-based, parents-child relationship-based, or sibling-based. And then the second part of the application process would be like deciding whether it's going to be consular processing or adjustment status for the beneficiary. If beneficiary is outside of the United States, then approved I-130 case will be transferred to the National Visa Center, where beneficiary will need to submit the required civil documentation. And then case will be finally transferred to the U.S. Embassy in the country where the beneficiary is currently residing, and the beneficiary will need to go for the immigrant visa interview. However, if the beneficiary is already inside the United States, the beneficiary may apply for an adjustment of status by filing Form I-485 with USCIS. And as part of the I-485 application package, the beneficiary may also apply for I-765 work permit and I-131 travel authorization. Some situations requires additional processing. For example, if it is an immediate relative case based on marriage-based, once you file it, USCIS will impose a condition on the green card if the marriage has not been more than 2 years. So in that case, beneficiary will need to go through the condition removal processing and application after 2 years one more time. So next slide. EB1A extraordinary ability. This is so first category of employment-based green card cases in the U.S. immigration system. So this green card is very similar to O1 visa, and particularly O1A is the one that very similar to EB1A. So if you have already successfully build up your O1A visa case, then you could utilize the O1A case file to prepare EB1A case as well. In order to get the successful result, you have to meet at least 3 of eligibilities listed on this slide. Basically, you have to prove that you are on top of your field in multiple ways. Again, the eligibility test is very similar to O1A visa, but please keep in mind that the level of review for EB1A is generally higher. For example, if your O1A was approved, but your qualification was just enough to meet the minimum requirement, that does not necessarily mean that you are ready for the EB1A green card case right away. In this situation, it is usually better to wait and a little longer to build up your strong record for the EB1A case. USCIS usually want to see stronger and more independent evidence than O1A for the EB1A green card case. For example, media coverage should ideally focus on you and your own individual work, not just your company or company's achievement in the industry. In simple terms, O1A approval could be very positive sign for you, but it is not automatic green light for EB1A. So you usually want to stronger, more mature, and more independently document records. So, okay, so keep in mind about EB1A eligibility tests. And now let me turn it over Ian, who will guide you through the next part of our presentation. He will cover more details of EB1A as well and other employment-based green card case categories, particularly EB2 national interest waiver and PUM cases. So please stay tuned.
Perfect. Thank you very much, Yonki. It's great to be here. And the EB1A is a great category for a green card that we move a lot of people to. And as Yonki said, a lot of the time they have an O1, but sometimes they have other types of visas as well. And they do things in the United States that makes them rise to the level of applying for an EB1A. The another area that we see a lot of people move to a green card with is EB2 national interest waiver. And what this category really is saying, it's saying that the person is coming to the United States to do something, and the thing that they're coming to do, the term we use for that is their endeavor. That their endeavor, the government feels that that's of national importance. So it's important to the government, and as a result of that, the government says, hey, let's give them a green card. So the way that this particular green card works is that we start with the fact that this particular green card is in the EB2 category. And now EB2 is broken out into two categories, one being a company sponsoring you for a green card under a professional category, and the second being national interest waiver. But to get into either of those EB2 categories, you first have to look at some threshold considerations. So in order to apply for a national interest waiver or to be sponsored for a green card by a company under the EB2 category, you first have to have either and keep in mind the key is either. So either an advanced degree, so it's going to be a master's degree or higher, or a bachelor's degree plus 5 years of progressive work experience, or something called exceptional abilities. And exceptional ability, there are a list of criterion, and you have to look to see whether you've met three of them to get the exceptional ability classification. So, it certainly, when you're looking at this as well, if you're doing advanced degree, the degree has to relate to what your endeavor is doing. Same thing if you're doing using bachelor's plus 5 years experience. Both the bachelor's and the 5 years experience have to relate to your endeavor, and similarly with exceptional ability. So now, once you've met the threshold issue, so let's say that you are an entrepreneur and you're looking to get an NIW and you have an MBA. So an MBA is a master's degree, so you have an advanced degree. So you've checked box one, the easy box, and now you have to look at the more difficult one, and that is looking to see whether or not your endeavor meets the NIW requirements. And the NIW requirements are spelt out based on a case. The name of the case is Matter of Danisar, and they set out three requirements that you have to meet in order to get a national interest waiver green card. And first is that your endeavor has to be of substantial merit or national importance. So this is a very high bar. So it's not just that there's a labor shortage. So I'm a pilot, and the government wants pilots. It's or I'm a teacher, and that's an important job. So I get national interest waiver. It's going to be much, much, much higher bar. So rolling out of a new process or invention of something that's going to be important to the United States, things like that are the types of things that you're going to look at when you're looking at something being of national importance. I use two terms, substantial merit and national importance. Often substantial merit is easy. So teachers, the government has acknowledged that the job itself has substantial merit. But the harder one, and it's not an or test, it's an and test. The harder one is national importance. And that's the one where you really, the bar is set quite high. So it could be as well that we do this to move some people from E2 to national interest waiver, where we say that there's the economic benefit associated with the particular endeavor, like job creation or other economic benefit, is what is pushing them past that bar. That's sometimes we can use that. And often with a national interest waiver petition, there's going to be a number of expert letters that are included in the petition that are used in order to bolster either the national importance or the second criteria, which is that the individual is well positioned to advance the endeavor. So when we're looking at the individual being well positioned to advance the endeavor, we're really looking at their background, their resume, their educational background, but more importantly, how far have they advanced this endeavor, and do they have a track record for this particular endeavor? Like, so if they are saying that they are going to create a particular process and roll it out in the United States, and they've already done that in their home country, then that's going to be a significant push towards meeting the second criteria. And then finally, the third element is that the government has already said that they believe that protecting US jobs is of national importance. So we go through a test where we kind of say, okay, well, if that's nationally important, why should we give this person a green card anyway? And so that's an assessment that's done to do that. Now, when we look at both national interest waiver and extraordinary ability EB1A cases, we now we're looking at how is it that you apply for them? What's the process? And they both have the unique ability to apply for them without a sponsor. So you don't need a job offer, you don't need a job. You can independently apply for these. So you can self-petition. And it is a two-step process where you file an I-140, and the I-140 is kind of the showing the hard part. So under NIW, it's showing that you've met the three prongs that I just talked about. And if you're looking at EB1A, the Yongki went through, it would be showing that you've met at least three of the eight criteria that are listed there. So that's the first part. And then you have the second part, which is the I-485, or consular processing. The I-485 you can do if you're in the United States and the category is current. But if you're outside the United States, you could go through the process where you're actually doing consular processing. And then if the category is current and you're in the United States and you can file an I-485, you are able to file an I-765 and I-131. The 765 is work authorization. The 131 is travel authorization. So even though you may wait for a bit for the adjudication, you can get employment and ability to travel in the interim. Both of these petitions do have premium processing associated with them. For EB1A, it's 15 business days. For NIW, it's 45 business days. So you can pay the government $2,900 and they will adjudicate the petition faster. There's no premium processing associated with the I-485 or consular processing, but the hard part of the petition is the I-140. So you it can take some comfort in the knowledge that you have that approved. You have that approved. The next green card category is one that a lot of people move to, people on H-1Bs, people on TNs, people on lots of different categories they move to is related to a company sponsoring you for a green card. So this falls under two categories, EB2 and EB3. And EB2 being the professional category. And again, keep in mind that you have to meet the threshold requirements. And then EB3 would be more for unskilled labor or people who don't have a degree. So this is a process where the company it's called a perm process. And the company is trying to prove to the US government that they can't find a qualified US worker. So it is quite an artificial process where they have to post a job description, post the job as available, and see if people apply. And if they apply and the person is qualified, then the perm can't go through. But it is a way that a number of people get green cards in the United States. So it's probably one of the most popular ways. Outside of maybe marrying a U.S. citizen. But it's definitely one that is available. The processing time, it can be quite lengthy. It can take about 18 months to go through the Department of Labor process, and then a similar amount of time to go through the immigration process. And this too, the filing is very similar to what we just talked about, where an I-140 is filed, and if the category is current, and the person is in the United States, the an I-485 is filed, and that can allow the person to file a work authorization and travel authorization as well. And the final EB5 category that we are going to talk about is EB5. And EB5 is one that we have a lot of, again, E2 clients that entrepreneurs who come and start a business and then they want to move to a green card and then they continue investing in their own business and apply for EB5. We also have people on other visas, TNs, H-1Bs, others, and they decide that they want to live and work in the United States, and then they take their money and invest it in what's called a regional center. And what we have here is the EB5 program. At the crux of it, there are two main requirements. The first being that you have to invest 800,000 or 1,050,000 in a business, in a new commercial enterprise. The amount that you're going to invest is going to depend on where the business is located. If the business is located in an area that has higher unemployment, it's going to be the lower amount. If it's in an area that's rural, it's going to be a lower amount, and then everything else is going to be the higher amount. And the program has the other second big part of the program is job creation. You have to invest the money. That's part one, and then the second part is that you have to create 10 full-time jobs. So those are at the crux of this particular category. That's what has to happen. Now, there are EB5 is further broken out into two different facets. So one is regional center, and the other one is direct investment. So the regional center is the idea where there's an organization that wants to raise a bunch of money. So let's say that we have a organization where we have um, individual that a hotel, like let's say a hotel like Hilton hotel chain that wants to raise capital, and they say, "Oh, I want to raise $100 million, and I'm going to utilize the EB5 program to do that." And they do that, and then they go about creating the job. So that's why that particular one is appealing to some people because they prefer a much more passive investment and not have to do anything. Now, the other is direct investment, where this is where we see a lot of our E2 clients doing this, where they have a business and they don't want to invest passively in another business and take that risk that's associated with that. So they invest in their own business, and that is very possible as well. And then they create the jobs themselves. The EB5 program does have a fairly extensive and detailed requirement to prove the source of funds. So that's something that is, it's not for the faint of heart. It is quite an extensive, detailed process. This is a three-step process where we file an I-526 petition, and then if you're in the United States, you can file an I-485, provided the category is current, or if you're outside the United States, you can do consular processing. Then when you have had the green card for 2 years, you have to go back and file an I-829 petition to remove the conditions, to show that you've actually been able to create the U.S. jobs. And I think that, oh, no, a couple more. We have a couple more ways to get green cards in the United States. Diversity lottery, so that's where they pick 50,000 or so people from different countries and give them a green card every year. That's one way, and we often have at least one of our clients who's working on an E2 or some other type of visa that actually gets that particular wins. It's lucky person. They should play the lotto the lottery when it's a lot of money, because if they're lucky with this, then maybe they'd be lucky with that. There are humanitarian-based green cards that sometimes people will help the government with solving a crime, or there's green cards associated with people who are victims of domestic abuse and things like that. And then, of course, we can always hope on immigration reform occurring at some point. The other things to kind of consider here are the timing considerations, because some petitions like EB-5, they take a long time to be adjudicated, like 3 to 5 years. And then also sometimes there are backlogs that occur. So the visa bulletin that Yonki mentioned earlier, that's like a crystal ball with respect to when things are current and when they're not current. So you do have to make sure that your underlying status, that's being maintained. So that's something that you have to see and show. And then, because if you have a visa, let's say you have a TN visa and you're in the United States and you want to apply for a green card, the TN visa is not a dual intent visa. And whereas if you have neither is an E2, whereas if you have an H1B or an L1, then there could be an instance there where you're able to utilize that to stay in the United States and travel back and forth. And then we have a lot of clients who do parallel green card strategies where they may initially do EB-5, but then they get married, and then we do a marriage-based petition for them. So there is quite a bit of that going on. And really planning, I think, is key for this. One last visa that we didn't talk about that people do move from a non-immigrant visa to an immigrant visa is we talked about EB-1A, but there also is an EB-1C category. And the EB-1C category is very similar to the L category. And the L category is one where there's a company abroad, and the company decides that they want to set up an office in the United States, and they do that. And if they meet certain criteria, they are able to set up the office in the United States and get an L visa, which is a dual intent visa, and get an L visa to be able to do that. So that's something to consider as well. And I think that was it. So I will turn it back over to Yonki.
Okay, thank you, Yan. That was very informative and great presentation. And with that, let's go ahead and take a look at the questions. Okay, we do not have any questions. Well, in that case, thank you all for joining us today. We hope this webinar has been very helpful for your journey to the green card in the United States. And if you have any additional questions, okay, we have one question, something I don't know. Thank you for this seminar. Something I don't see very often is TN to family-based green card case. Can you specify a little more your question? What do you mean by? So you
Yeah.
wanna apply family-based green card case when you are in TN visa?
Yeah, I mean, we definitely see that as well. People that are on TN and they get married in the United States, that certainly happens as long as they marry a U.S. citizen. That's certainly an option for them to be able to get a green card. So yeah.
Yes. So you could apply family-based green card case or what when you are in TN visa. But with TN visa, basically doesn't allow you to have an immigrant intent, so you need to consult with the immigrant expert to carefully design the case directions. So,
Exactly.
thank you for your time, and we look forward to seeing you at our next webinar.
Perfect. Excellent. Thank you very
Thank you.
much. Okay. Take care. Bye-bye.